Thank you for having us. My colleague Yvonne and I are very happy to be here today. Thank you for giving us that opportunity as well. A little bit about our practice. We typically represent foreign investors, companies doing business in Texas. So that is our niche market. It's a bit strange for us to be presenting in English today because the majority of the time we're presenting in Spanish. So, we're trying to reverse the terminology a bit. And, when Julia contacted us about this opportunity, we were scrambling to find an existing presentation because all of our presentations are in Spanish. In either case, there's specific items, specific issues that we pinpoint when the prospective business owner is foreign. It's a bit different for domestic individuals. So if anyone is interested in inquiring as to what applies to foreign investors, foreign individuals, foreign companies, we'd be happy to discuss that with you. But for purposes of this presentation, we're going to focus on domestic.
I will speak a little bit about some prior things to do before starting a business or on the early starts of a business. And this is something that most of the time it gets just forgot. It's to have a written business plan. This will help you not only to have a roadmap for yourself, but also in case you want to have an investor in the future, or if you need an advisor, so you don't have to be explaining over and over again, and you will have a clear idea of what you do, and you can transmit that in an easier and more structured way. I would recommend that you should keep this simple. Usually one page or 2 pages long, that will be enough. Unless you will need something different. I can think of very few cases where you will legally need to have something more complicated. For instance, if you want to have a Mexican chef on your business and you will sponsor his visa, you will need a more detailed business plan for immigration purposes, for instance. Other than that, I would say that you can keep it simple, and that will be usually enough for that. Usually, it's recommendable to form a legal entity. You shouldn't be doing your business on your own, because that way you will be as protected as you should be with a legal entity. We can see this as if you have 2 bags. In one bag you will have all your assets, all your personal assets, your residence, your car, everything you already own. And when you form an entity, you will have a second bag. In this second bag, you will have every asset of the company. You will have the entity's car, entity's whatever, the hardware, software, whatever the entity owns, right? It is important to always keep these 2 separated. And that's one of the most important formalities that you will need to respect, because think about it this way: you will have a separate credit card, for instance, for the entity, right? And sometimes you forgot your own credit card. Please don't use the business credit card to pay for your own things, because that way you will be undermining this separation, and eventually this will cause an issue. Why would you do that? Because if for any random reason you have any liability for your business, whoever sues you will go after your personal assets instead of just like the company assets. That's why we're separating this into different bags. So even in some scenarios, it's important to have more than one entity. Let's think about trademarks. Sometimes we forget that trademarks, an intangible asset, is probably the most expensive, the most important asset you will have. So you will want to have a holding company that owns this trademark, that owns maybe your most expensive assets, and then have a second entity operating. Therefore, you will be giving another layer of protection for your company's assets and not only for your personal assets. So we have now 3 layers of protection, right? So that's why we consider important forming a legal entity. Of course, there are many options as of now. The most usual as of today will be a limited liability company, which is versatile enough a legal entity to cover most of the necessities. Again, this is always on a case-by-case basis. Therefore, but an LLC will provide you with tax selection. For instance, you can pay taxes as a corporation, or you can pay taxes as an individual with a partnership or disregard entity tax selection. That will mean that all the income of the company will pass through to your personal, as an individual, and you will be filing your taxes as an individual with all the income from the entity. This is one of the main differences. As the last point, I would like to address that as another layer of protection for your assets will be to get a commercial liability insurance. That will be if you by any chance have any liability to pay, the insurance will cover you. So the person who is suing you won't get to your assets, and the insurance will cover that.
And also understanding the policy and what you're actually covered for. We had a client here locally in San Antonio who owns a restaurant, and the restaurant burned down. They assumed that they were covered. This is what their insurance broker told them. They came to us trying to enforce this policy, get coverage, and it turns out that they were not covered in the event of fire. So this business was actually $1 million out of pocket. It was simply because they didn't, for whatever reason, take the time to carefully review their policy. Now, this person happened to be a Spanish speaker, so there is potentially a litigation claim there with respect to the person that sold them the policy, whether certain disclosures were made, whether they were properly informed. But again, I get these calls from many small business owners, asking, hey, but I'm covered for this, and unfortunately, a lot of the times they're not. They assume that they're covered for cybersecurity risks, and again, that's an additional endorsement on many of the policies. So it's important to understand your insurance coverage. Ideally, we would say it's important to have, your legal representative review that. That's what I always recommend to my clients. They always send us their insurance policies for review prior to signing on. So that's a good practice, or just, really trusting the insurance broker that you're working with, confirming that coverage, taking the time to read it. It just depends on your level of comfort, but obviously I would always say, if you have those means available, work with an attorney. Something else important that David alluded to earlier with respect to the clinic is the importance of working with a CPA. And it's also what Yvonne was discussing. Depending on the type of business that you're going to be carrying on, depending on whether you're going to have business partners, what your financial projections are, an LLC might not be the best entity structure for you. You might be better off with a corporation. So it's important to have those discussions up front, invest a little bit up front. A lot of the times, at least in our line of work, we're doing cleanup. And, it's unfortunate. People come to us when there's a problem, when someone else, is using their intellectual property, when someone, they have a situation like my client with this insurance policy that didn't afford them coverage. So again, there's many means out there specifically for small businesses, and you guys are, in the right place by being here today. We understand that, legal services can be expensive, but again, a lot of times you need to work that into your business plan and understand that it's a cost of doing business, and a lot of the times it's better to be preventative than, responsive. So it's important, once you decide to form your entity, forming the entity is not too complicated or costly. Filing a certificate of formation, for example, with the state of Texas is it's $300. So really, The cost is in understanding, working with your CPA, working with your attorney to determine the best structure for you, and then getting those entity documents going. If you're a sole proprietor business, it might not be too complicated, but if you are working with a group of business partners, this becomes extremely important. We often, get asked to intervene in situations where the business partners are having a dispute as to how the profits were going to be distributed or who owns the intellectual property. There are situations, for example, when a client has the patent or they have the trademark, and that is their contribution to the business. On the other hand, there's another partner who is investing the know-how, and there might be another partner who is investing the money. So it's important to have all of these agreements up front to understand everyone's rights, obligations, their responsibilities. That way, you have a roadmap in the event of any disputes. So oftentimes in our company agreements or bylaws, we have these agreements among the shareholders that establish the way the corporation or the LLC is going to be operated. It's also very important to establish who has the authority to act on behalf of the business. It might be the case that there's one person that has excellent business acumen. They're the ones that, really, they either have the business background or they have the education. They're the ones that are going to be the best suited for administering the business. While you might have other individuals who, they're great, they can provide the money, but they may not take the best business decisions. So it's best to have all of this up front and clearly establish who has authority to act on behalf of the business. For our Mexican clients, Yvonne and I deal with clients, investors from Mexico all the time. They come here and they are completely spooked because the concept of implied authority does not exist in Mexico. So implied authority means if I, come here and I say my name is Natalie Cerón and I'm a partner at Cacheaux, Cavazos in Newton, I sign a document on behalf of the firm. Everyone here assumes that I'm acting in good faith and that I have the authority to do so. Well, in Mexico, in order to, represent a Mexican company, you need to have a power of attorney. And your power of attorney specifically needs to say that you have the authority to carry out that act. So that's just, a crash course on Mexican law for you guys. But, so we do that a lot. We have to explain that concept to our clients. So they come here and they say, well, no, wait a minute, you need to include all these limitations in the company agreement. We don't want them taking these decisions. But in any case, it's something that I think has showed me to exercise even more caution with my domestic clients because it's important. For some of the larger corporations that we work with, we actually have corporate authority policies. And so it'll tell you, for example, if it's a transaction above $10,000, at least 2 officers need to sign. If it's a transaction that's maybe above $100,000, then one of the shareholders is going to need to sign on. So that's just some example. When we're forming an entity, we have your certificate of formation. A lot of times you'll form, for example, ABC Holding Company Corp. But you might want to operate, before the public under a different name, and you can do that. In order to do that, you would file what's called a DBA. A lot of our clients, for example, that have franchises like Holiday Inn, some of the hotels here locally, they'll require a DBA registration at both the county and the state level. And that, again, that's another way to protect whatever name it is that you're operating under. Something else important to consider, you need to respect the corporate formalities of your business. Even if you are a sole proprietor, you form an LLC, you need to act like a company. You can't act as an individual and act through the company because then you set a bad precedent and it's not clear to the public at large whenever it is that you're acting as a company or as an individual. So when you open your company, you're going to be signed a tax identification number. So that's equivalent to a social security number. So your company is going to have its own personal identification number. That's what you're going to use to open your bank account. And that's going to be a unique identifier moving forward. Also super important, and especially in this specific case where we talked about having other partners, maintaining proper bookkeeping. The company does have a duty to make books and records available, at the principal place of business, and this is something that lawyers love to hone in on. Whenever we have, just investors that put in the money, but their administrator, their CEO is not maintaining proper books and records, that's one of the first things that we'll focus on if it ever comes to litigation. Another general recommendation is to use written agreements. I have so many clients, and Yvonne can vouch for this as well, who will say, well, we had a handshake agreement, right? It was a handshake, it was a gentleman's agreement. Well, unfortunately, those don't always hold up. And how do we go back and trace what that handshake agreement, what that gentleman's agreement was? So to every small business, we would recommend, whatever is your line of business, whether you're selling a product, whether you're selling a service, have a very standard contract in place. That shouldn't be something too difficult to come by. Have your terms and conditions for sale or service so that once you're selling to the general public, you have something in place, something to look back on. Specifically, we want to make sure that you have in there information on what happens in the event your payments are late. Is there any interest charged on late payments? When is a payment considered late? What happens in the event of a dispute? What are the rights and obligations of the parties? So we're actually working with a couple of clients right now, and they're pretty established businesses. I would say right now they're seeing sales of maybe 10 million, and they didn't have a good contract in place or terms and conditions. And so they have all these issues when they try and collect from their clients, because other than a couple of emails back and forth and he said, she said, there's nothing that we really have. And just having this document up front would have saved them so many headaches and just time and expenses.
Terms and conditions, are they, is it good enough if I had it, the terms and conditions in my invoice, where I say these are the services I will be providing you in upon payment, right? That's what the promise to deliver. Is that going to be good enough, or do I have to have something more formal where they have to sign? Because on my invoices they don't sign, so I'm just going to ask.
So typically what we would recommend is to have some form of acknowledgement of receipt. Ideally, it would be conspicuous language saying, I have read, acknowledged the terms and conditions, or I have read, acknowledged that the terms and conditions are attached either to the back of the invoice or made available on the website. It's like a lot of the times when you update your cell phone and you get, the terms and conditions that pop up and everyone just clicks, or maybe some of you read them, maybe our IP attorney here reads them, but a lot of times we don't, right? But at the very least, there is evidence that they have made this effort to inform us of the fact that they exist. So I think that should be sufficient. But if you have another mechanism, or if you can make the text, referencing those terms and conditions bold, uppercase, I think that would be a good practice. So just real quick, if you'll see on the screen here a sample signature line, this is what your signature line should look like whenever you're signing any contract document on behalf of your business entity. So you'll see you have the name of the corporation, by, and their position as either president, manager, or CEO. So we'll talk a little bit about compliance with labor laws. As you all know, Texas is an at-will employment state. A lot of times for small business owners, it's overly cumbersome and not necessary to have detailed employment agreements. Sometimes a simple offer letter will do. That's generally our recommendation, to have something in place that memorializes the agreement between you and your employees. In the case where we talked earlier about a bakery and the trade secrets, having access to these recipes, it would be important to include in that offer letter some type of confidentiality clause, so that any information that these employees receive, you have an acknowledgement that it will be maintained confidential. If we ever have an issue, then that's more evidence that we have on our side to prove that we did our due diligence to maintain the confidentiality and the integrity of that recipe or that trade secret. Really quickly, an employee handbook is always a good idea. Depending on the number of employees that you have, At all times, we just need to make sure that safety issues are complied with, wage requirements, that you're fairly paying your employees overtime, and that you're treating all employees fairly. So you can't offer one group of employees paid time off, vacation time, but not offer it to others. So those are just important considerations. Document. A lot of the issues that we see are whenever there's an employee incident and it wasn't documented. We have a supervisor saying that he gave a warning, but there's no documentation. Then you get a notice from TWC. You have to defend your action in that hearing, and they'll ask you up front to send over all of your documentation. So again, if you have employees, a small business, document. There's actually, the Texas Workforce Commission has a lot of employer resources, so the information is here, and we'll share those slides for anyone that wants to look into that. Also, really quickly, look into the categorization or classification of employees versus independent contractor. That is really important. A lot of the times, we assume that everyone can be a 1099 employee, and that's not the case. There's a 20-factor test available on TWC. Ultimately, it comes down to whether the service recipient or the quote-unquote employee had the right, the quote-unquote employer had the right to direct or control the worker. That's not the only test. There's other factors that are considered, but misclassifying a worker can cost the business taxes and interest, and a visit from TWC. Just as a bonus, something that we discussed, the importance of marketing your business and definitely getting registered if you qualify as a minority-owned business or a woman-owned business. There's so many benefits that are available to you. Locally, I'm aware of NAGO. I know that NAGO has a big presence here in San Antonio for the women owners, and the Southwest Minority Supplier Development Council. I'm very familiar with this issue because I actually worked on our firm's minority certification. So if anyone has any questions on how to become a minority certified business, just please feel free to approach me, send me an email. I'd be happy to help you. But essentially, you get access to larger corporations. You have access to their job fairs, and you can register as a supplier through their supplier portal and have more access to those opportunities.